This module deals with the practicing and regulatory requirements necessary for those who are public access qualified. It also explores how the Money Laundering Regulations 2007, Proceeds of Crime Act 2002, and the Terrorist Act of 2000 apply to barristers in practice. We shall also consider the Consumer Protection Unfair Trading Regulations of 2008 and the government's attempts to address consumer detriment caused by inadequate levels of service. Under Section 14 of the Legal Services Act, it is a criminal offence for a barrister to carry on a reserved legal activity unless they are authorised to do so by a practising certificate. It's also a breach of the Code of Conduct. The Bar Standards Board has a formal process for the renewal of practising certificates, which is now an online process. All practitioners are required to have an individual online account to complete authorisation. As a result of the Legal Services Board Working Group recommendations, a new training regime was introduced in October of this year to provide further assurance that those undertaking public access work would have the knowledge, understanding and skills required to conduct such work competently. Existing public access barristers will need to have undertaken a top-up training course by October 2015 or cease to conduct public access work. Barristers of fewer than 3 years practising experience must have completed the necessary training and assessments, but are also required to 1. Seek feedback from their public access clients on the service provided, and 2. Maintain a log of public access cases they have dealt with, including any issues or problems that have arisen, and make this log available on request to the BSB for review. Part of the authorisation to practice process requires barristers to declare that they have obtained and paid for adequate indemnity insurance, and to confirm whether they have completed the requisite amount of CPD activity. Barristers should be aware that failure to complete the required number of CPD hours can result in a finding of misconduct. Barristers should be aware of the dangers of being used to assist with money laundering and terrorist financing. Once proceeds of crime are in the financial system, layering obscures their origins by passing the money through complex transactions. The criminal is then able to make the funds reappear as legitimate funds or assets. These funds will be invested in legitimate businesses or other forms of investment, often using you to buy a property, set up a trust, acquire a company, or even settle litigation. This is the most difficult stage of money laundering to detect. It is likely that relatively few barristers will find themselves subject to the requirements of the regulations. Those most likely to be caught by the provisions are members of the Chancery Bar Association, working in specific sectors such as A. Tax advisors, B. Those instructed to advise at the planning or execution stage of the buying or selling of real property or business entities, C. Those instructed in relation to the setting up, structuring or management of companies, or D. Those involved in the creation, operation or management of trusts, companies or similar structures. Those who are caught by the provisions of the Money Laundering Regulations 2007 as amended need to carry out customer due diligence. This involves identifying the client or beneficiaries and verifying their identity. It also places an obligation on the barrister to obtain information relating to the purpose and intended nature of the business relationship. Records also need to be kept for 5 years, and you should make sure you implement internal controls and measures to assess the risk level particular to your work in order to minimize risk. While the regulations are likely to affect only a limited number of members of public access barristers, the money laundering offences created under the Proceeds of Crime Act 2002 are of general application, irrespective of whether or not an individual's practice falls within the scope of the regulations. Under Part 7 of the Proceeds of Crime Act, sections 327 to 329, it is an offence to conceal, disguise, convert or transfer criminal property or remove criminal property from the UK. enter into or become concerned in an arrangement which they know or suspect facilitates by whatever means the acquisition, retention, use or control of criminal property by or on behalf of another person. Acquire, use or have possession of criminal property. There are various defences available to a barrister under sections 327 to 329 if he makes an authorised disclosure under section 338. It is also an offence under section 330 not to disclose knowledge or suspicion of money laundering. However, a barrister can rely on a defence if he makes disclosure as soon as is practicable, has reasonable excuse for not disclosing the information or other matter, or he is a professional legal advisor, and the information or other matter came to him in privileged circumstances. The Terrorism Act 2000, as amended, criminalises the provision of monetary support for terrorist purposes. It is also an offence to become involved in an arrangement or know or suspect that money or other property may be used for terrorist purposes. The principal offences in sections 15 to 18 apply to all persons. However, the specific offence of failure to disclose and the two tipping off offences apply only to those in the regulated sector. Any disclosure should be made to the National Crime Agency, which is a law enforcement body devoted to dealing with organised crime within the UK. Barristers should be mindful of the danger of ignoring the legislation. There are many risks, including criminal and disciplinary sanctions, civil action and damage to reputation leading to loss of business. These risks must be identified, assessed and mitigated. The Consumer Protection from Unfair Trading Regulations of 2008, CPRs, came into force in May 2008 to prevent business practices that are unfair to consumers. These regulations impose a statutory duty to trade fairly and honestly with consumers and apply before, during and after a contract is made. Barristers should be aware that these regulations will be amended by the Consumer Protection from Unfair Trading Amendment Regulations 2013 in due course. These regulations impose a duty on barristers not to mislead their clients in such a way that would cause the average consumer to take a different transactional decision. Barristers are advised to familiarise themselves particularly with Regulations 3 to 7.